Welcome, everybody. My name is John Tsulis. I'm the director of the Institute for Ethics in AI, and our topic in this colloquium is AI in the law or AI in place of law. And hopefully there'll be an answer at the end. I'm really delighted to welcome our main speaker, Gerald J. Postuma, who is the Boshamer Professor of Philosophy and Professor of Law at UNC, Chapel Hill. He's one of the world's leading philosophers of law and the author of a massive study of Jeremy Bentham and the common law tradition, second edition of which came out in 2019. He's also the author of many fine articles in legal and political philosophy. And most recently, he's the author of a book which is an exciting event in the world of jurisprudence, a book called Law's Rule: The Nature, Value, and Viability of the Rule of Law. There was a quite famous Oxford legal philosopher who recently said, people shouldn't bother writing about the rule of law because it's all been said. But this book proves that this isn't the case, that these fundamental topics have to be revisited in light of new concerns. So one of the things that I was very delighted to see was Jerry's book has a discussion of equity and mercy in that context, which were topics that were really ignored in recent years. And there's also two topics on the way the digital revolution influences the rule of law, and that will be the focus of today's discussion. So, Jerry, it's just a real pleasure to have you here. We have three fantastic commentators as well. First of which is Dr. Natalie Byrom. She's the Director of Research at the Legal Education Foundation and the founder and director of Justice Lab, which is a policy evidence center using data and evidence to tackle the most pressing problems facing the justice system. Natalie's a very impressive person, the kind of person that when you meet her, you wonder whether you've wasted your life on trivia. She's very passionately committed to using data to enhance the quality of legal justice. And she gave a talk once where she mentioned one of the people whose opinions were sought. This is someone who was, as it were, the sharp end of the legal system. And she said, they think we don't care, but they don't ask us if we do. And I think if the digital revolution has any kind of redeeming moral aspect to it, one aspect of that would be enabling ordinary people to have a voice about matters such as the justice system that can affect them in quite dramatic ways. Second commentator is Professor Timothy Endicott, who has the unique distinction of being both a leading legal philosopher and also a leading administrative lawyer. Timothy is the holder of the prestigious Vinerian Chair of English Law at All Souls College here in Oxford. It reminds me a little bit of the famous Oxford philosopher J.L. Austin when he heard that Herbert Hart had been elected to the chair of jurisprudence. Hart at that point was a philosophy tutor. He said, what splendid news, another province falls to the empire of philosophy. But Timothy's gone one further. I mean, ordinary lawyers don't care about the chair of jurisprudence, but boy do they care about the Vinerian chair. So to see a philosopher, Timothy, occupying that chair, it just is the best news imaginable for us legal philosophers here. And of course, Timothy is the author of Vagueness in Law, which was published in 2000, and Administrative Law, published in 2021. And last but not least, we have Professor Sarah Green, who is a UK Law Commissioner for Commercial and Common Law. She's held that post since January 2020. It's a kind of a pandemic exercise, I guess. She's previously held academic posts at Bristol, Oxford, and Birmingham, so we're delighted to welcome her back. Before her academic career, she was a software consultant at Accenture, and Professor Green has written books and articles on many issues at the intersection of law and technology, such as virtual currencies, smart contracts, and blockchain issues regarding intermediated securities. So the way we're going to proceed is we're going to have Jerry talk to us for about 30 minutes, and then I'll invite each of the speakers to give a comment of about 5 minutes, which I will strictly time. And then we'll throw it open to a general discussion, including questions from people who are following us on YouTube. So if you are following us, please use the chat function to do that. But now it's my great pleasure to turn over to Jerry.
pleasure it is to be here. I've not ever been in this particular venue, but I have been around Oxford from time to time. I arrived here on Monday, and I spent a few days trying to recover memories. This comes as something like experiencing an earthquake, but I realized while here that it is actually 50 years ago that I was a graduate student here. I hate to actually mention that, but I'm humbled by that, but I'm also humbled by the fact that these wonderful colleagues have agreed to help me think about AI. I don't regard myself as an expert in anything. I'm a philosopher, so I'm an expert in everything, but actually in nothing. And so it's really great to have such accomplished colleagues as well. I want to begin my discussion with a disclaimer. This talk was not written by ChatGPT. At least they would like you to think that. I wrote this chapter of my book published now in November, but I wrote this chapter finished it in the very early months, perhaps the late months of 21, the early months of 22. In clock time, that's at most 18 months, maybe 15 months. In technology time, it's a century. Chat bots were not known, at least to me, back then. And so the AI in this field is moving at warp speed, so much so that the very creators of chatbots and the like, Elon Musk amongst others, have called for moratorium. And now I read yesterday that the letter calling for that moratorium has acquired 27,000 signatures. Lots of people are worried. Their worries tend to be various kinds. There's the standard ones we've been worrying about for a long time, the radical opacity of AI operations and algorithms, the potential bias and partiality that seems to be plaguing it or could plague it. More recently, concerns about AI getting into, and chatbots and the like, getting into the hands of bad actors and creating even worse problems of disinformation than we currently face. Perhaps some people are talking also about loss of jobs of various kinds, and at one point even I've heard people talk it's getting out of control. We have lost control. My concern is a little different, at least the concern I want to address today. My concern rather is with proposals for what's called artificial legal intelligence, using generative AI to do legal work. And the thought here is that AI devices, machine learning algorithms and all that, should be introduced to do the work of lawyers, officials, judges, and the like, replacing them across the board. And the question for us is, should we welcome this or resist it as a degradation of our social and political and academic and legal lives? I want to set this concern in the context of the idea of the rule of law. I wrote this chapter after having spent a good bit of time trying to articulate a conception of the rule of law and to defend it. And then I thought I should address some serious challenges to the ideal of rule of law as I propose to understand it. And one of them is one of the challenges is the claim that there's no room for the rule of law in the international domain, the transnational domain. There's another that says there's no place for equity or mercy in the rule of law. We talked about this yesterday. But also the developments in AI and advanced technologies are such that they present potentially challenges to the rule of law as well. And I wanted to pay attention to that. What I propose to do today, very, very briefly, unfortunately, we could spend weeks on this. What I'd like to do very briefly is to first sketch in the briefest terms just enough of my proposed conception of the rule of law that you get some idea where I'm coming from when I ask questions about artificial intelligence and its potential artificial legal intelligence. Then I want to sketch what I take to be some characteristics of artificial legal intelligence, or what I call computational intelligence. And then go on to ask the question, what of value would be lost if we were to replace lawyers and judges and the rest of us who do legal reasoning? What would value be lost if we were to do that? And the answer is not obvious, I think, and I want to spend some time doing that. So first of all, my conception of the rule of law, I want to propose a conception of the rule of law, and it has these features. First of all, one needs to get a handle on the central concern that animates the rule of law. That concern, I think, historically has been the exercise of power. And what my friend Martin Krieger says is the special disease of the exercise of power, namely its tendency to be exercised arbitrarily. And the rule of law proposes law is the cure for that disease, or a cure for that disease. So here's my slogan. The rule of law is robust in a political community when it provides protection and recourse against the arbitrary exercise of power through the distinctive instrumentalities of law, the distinctive tools of law. So we have an aim, tempering the exercise of power, and we have a means, law. That's the core idea. This rule of law then provides a bulwark for protection of the powerless, a bridle on the exercise of power by those who are powerful, and, importantly, a bond that brings us and holds us together in a political community. The bridle is very important to see because power, those who wield and exercise power, are not required by the rule of law simply to submit to the law. They must acknowledge that others are in a position to assess their activities with respect to that. So accountability plays the crucial role in the idea of the rule of law. It's not enough to have laws there, to have principles, to have standards. There must be framework within which those who exercise power are held accountable to the law. The bond is important because the rule of law makes possible and serves, I think, a compelling vision of what it is and can be for us to live together in a political community. So this ideal can be articulated in terms of three core principles. I'll call the first sovereignty of law, second equality, the third fidelity. Sovereignty of law. The main idea here is law alone rules. Law rules. That means that the exercise of ruling power, governing power, is legitimate just insofar as it's authorized by, ordained by the law. But also, those who exercise power must do so through the law, by means of the law. And thirdly, it means that those who govern by or through law must themselves be governed by it. I call that reflexivity. That's what I mean by the sovereignty of law. Equality, very quickly, we won't spend any time on this today. Equality here doesn't mean equality of things, but it means equality of standing, you might call. I think of equality here as a kind of position vis-a-vis others. And so the notion at the core of the rule of law, of equality, is equality in the eyes of the law, by which I think we should mean those who are bound by the law must equally enjoy its protection and recourse. Thirdly, and this is a part of my conception that I think is unusual, I insist that the rule of law be underwritten by a certain kind of ethos. The problem is this. Sovereignty of law requires that law rule. But laws don't rule. People do. Plato told us that. And so how do we understand this idea of laws ruling, being the only ruler? And the answer, in my view, is that the law rules just insofar as there is in a political community a robust ethos, a set of responsibilities and relationships rooted in core convictions and commitments, according to which each of us must take responsibility for holding each other, and especially those who wield legal power, wield governing power, accountable to the law. It's a community-wide responsibility. Fidelity, then, is, I think, the animating spirit of the rule of law. The rule of law is an important moral political ideal, and it has normative force, or so I claim, but you might want to ask, on what basis? On what ground? I mean, it makes important demands on those who exercise power. It makes important demands on those of us who are to hold them accountable. By what right? And so I do spend a chapter in which I try to explain what it is that the rule of law, this principle, serves, the more fundamental moral value or principle. And here, what I propose is that the rule of law makes possible and serves a compelling vision of the community and of individuals' place in it. It brings under one normative root actually four different closely related moral values. One being equality, now understood as peerhood, having the status of being able to see oneself and others as bound together as peers. Secondly, individual dignity. Third, freedom from domination or subordination. And fourth, a sense of community that binds us together. Those are not independent values. They are brought all together into a single conception of a community, and I call that conception of value membership, on the model of friendship being a kind of important value for people. Membership binds together in interesting ways these four different but closely related values. Law, when it meets the demands of the rule of law, law, when it meets the demands of the rule of law, plays a key role in securing and sustaining and nurturing communities, political communities, that aspire to realize this value of membership. So much so far. Well, the law is supposed to provide some kind of resources for holding those who exercise power, accountable, resources for tempering the exercise of ruling power. What resources does the law provide? What tools are in law's toolbox? I want to mention 6, although I spent a whole lot more time articulating them. I'm going to do it really quickly. 1, these are salient features of law that I think are in the law's toolbox and help to serve the aim of the rule of law. 1, law is normative, by which I mean law orders social behavior, structures social behavior according to norms. It addresses norms to persons who take them up into their practical deliberation. So they are, its law is normative, first of all. It's not, it orders behavior through these norms, and not in the way you might say that the snake charmer orders the behavior of the snake. It doesn't goad, it doesn't simply cause, it addresses norms to those who are capable of grasping them and integrating them into their own practical deliberation. Secondly, important too, law is positive, not in the sense that it's, bright and sunny, but in the sense that it is the product of human activity, embedded in historical processes and the like. Thirdly, law must be public in a couple of senses. One, most important for our purposes, it must be public in the sense that it's addressed in the public to a public, that is, to people in a public, in a community, not individually to each party, but it's addressed to a public that's composed of many individuals that are engaged in social interactions at various levels. It's addressed to the public. Fourth, law puts at the disposal of us all a disciplined practice of deliberative reasoning. Law's rule is the rule of deliberative reasoning. That is to say, law doesn't govern by reason in an abstract sense. Law governs through the process of reasoning. And that reasoning process is modeled in institutions with which we're familiar, mainly courts and the like. But those are models of an activity that goes on outside of those forums as well, and even in the public domain. For this reasoning, it's not merely a matter of output that accords with rules. Rather, this is reasoning that follows rules and norms intelligently, appreciating that rules and norms are reasons and can operate as reasons and as potential justifications for actions. Fifth, law essentially involves judgment. To recognize utterances, first of all, we need judgment in order to recognize utterances as reasons, as rules, and the rules as providing reasons for action. We need judgment to bridge the gap between general norms or rules and particular applications. Thirdly, judgment engages the world around us, the world and the affordances it provides, that it helps those who reason legally, reason with the law and in the law, allows them to follow norms intelligently. The law involves judgment in order to assess the relevance of evidence. We need judgment to assess the relevant evidence and the relative credibility of those who give testimony. And finally, it needs judgment, requires judgment in order to decide what to do. We end up our process of legal reasoning with requirements on what we should do. The question now is, should we do it? What should we do? Judgment is always involved in making that move from what the law requires or permits us to do to what we should do. And finally, law has an essentially moral dimension. I don't mean by that that law necessarily makes appeal to moral principles. Rather, what I mean is that reasoning persons are implicated in the conclusions they draw and the actions they take on the basis of the conclusions they draw. They must bear responsibility for those conclusions and for their actions, and they are liable to others who will hold them accountable for it. So the moral dimension is a dimension of responsibility tied to the overall concern of accountability. So now, that says a little bit about law's tools and maybe a little bit about what it is to reason like a lawyer. Let's contrast, well, let me compare that with, we won't contrast yet, let me compare that with what I call computational intelligence. AI devices, algorithms, machine learning, large language models, and the like, take information that we have and generate information that we don't have. It's sort of like espionage intelligence, right? You get new information from this espionage intelligence. And this information can be useful for decision making. But it's not a decision. It's information. Now, it's often said that these devices make predictions. But that's a little bit misleading, because what, in fact, these devices do, on the whole, is uncover correlations based on statistical analysis. So chatbots are, in a sense, if I can be really crude about it, forgive me, they are very sophisticated forms of autocomplete. Third, the output from such computational intelligence, to put it really crudely, bears little relationship to truth. Or to put it a little bit more kindly, it has little relationship to the world and all its complexity. It works on data of various kinds that can be found on the internet and elsewhere. It doesn't appreciate values and norms. They don't appreciate reasons as reasons. The problem isn't that, there's a lot of talk lately about the problem of alignment, that these AI devices are not tracking our values in some way. I don't think the problem, that's a problem, but the problem I'm concerned with here is not alignment, it's appreciation. They don't see reasons as providing justifications. So large language models can reproduce arguments, parrot them, but they can't recognize them as articulations of values and norms, or weigh them as reasons we might give that have some moral significance. They're curators of opinions. They don't engage them as opinions. Now, it's also true that a lot of the correlations uncover important patterns patterns of similarity, and that often leads to further kinds of applications and uncovering of further kinds of information. And one might be inclined to think of this as a kind of analogical thinking, reasoning by analogy. But I think that's not quite right, because to determine the relevance of similarity of one group of things, ideas, models, or the like, examples, and another, the comparables and the target and the source, the way in which they connect them is by way of counting. How many similarities? But analogical reasoning is a reasoning by which we see the connection between the source and the target as having some connection that makes practical or legal or maybe moral sense. So analogical reasoning evaluates these similarities, and relevance is then determined not by numbers, but by what makes sense. So to sum this up, computing doesn't perform legal reasoning just faster and more efficiently, in my view. It simulates it by doing something altogether different. There's no lex ex machina, you might say. So simulation replaces argumentation, calculation replaces deliberative reasoning. I want to also mention very briefly the approach that those who defend AI in the artificial legal intelligence speak of social ordering by artificial intelligence in two different ways, perhaps more than that. I'll just mention two. One is by way of hyper-particularized personal directives. They're tailored with precision to individual actions and circumstances in light of the particular features of each individual. The model here is, as it were, a one-to-one. The direction giver and the direction receiver. I'm brought to mind of Hobbes's model of the activity of the sovereign. The sovereign was one who gives commands to each individual. Notice it bypasses deliberation and goes directly to action. The other, I'm drawing here on the work of Lawrence Lessig. He distinguishes between the mode of social ordering I'm calling normative, with what he calls architecture. That's his term of art. Architecture shapes and channels behavior through non-deliberative means. So unlike scripts and recipes, well, let me give you an example. The example he gives is speed bumps on a neighborhood road. They get you to go slower, but they don't do it by saying speed limit 20 miles per hour. And they don't even say things like drive here as if your kids lived here. Right? What they do is they put obstacles in the way of you doing so. When in my town in Durham, North Carolina, there are streets that have just enough room for one traffic lane and two parking lanes. So what they do, they engineered it so that the traffic lane snakes around and cars park in the other places. And so what you get is you cannot go very fast through there just because you've got cars parked every once in a while, and you have to snake through it. That's architecture. They order social behavior, but through non-deliberative means. Sometimes theorists and the like talk about these as if they were scripts or recipes. But scripts and recipes work through our deliberation, through our judgment. And some of us don't have enough grasp of the world around us to be able to follow those scripts very well, and we do, or those recipes, we do them very badly. If my wife were here, she was an earlier lecturer of mine, she would tell you, I'm very bad at it. Why? Because I can't follow a recipe. I don't have the appropriate experience over time for that. Thank goodness she's back home. So what AI does in this mode of social ordering is it goads rather than guides. It offers guardrails rather than guidance, regimentation rather than regulation. Now, if that's a fair description of what some people want to call artificial legal intelligence, we might say, okay, that's different. So what? It's a difference. So what? What's lost? That's what I want to turn to. Now, keep in mind that the objective of the rule of law was to temper the exercise of power, to protect and provide recourse against the arbitrary exercise of power through the law. Now, the rule of law ideal recognizes that there might be other ways of tempering power. So, you might think this is just an alternative way of doing the same thing, maybe even more efficiently. I think it would be unfortunate in one respect anyway. That way of thinking of it is unfortunate in one respect, because the rule of law ideal's choice of law was not just a matter of what seems ready to hand, what seems maybe efficient for the time being, 100 years, 200 years, 1,000 years ago. Right? There's a closer, I might think even principled reason for going for the law, given what its aim is and the underlying value it means to serve. So law is chosen for principled reasons, or reasons internal to the very kind of aim it has. Law provides a mode of governance and a mode of association. We've seen bits of that in my opening comments. And I want to look at what's lost by looking at it under those two heads. Looking first at law as a mode of governance, and then law as a mode of association. So, first of all, what's lost if AI were to replace law as a mode of governance in the interface between those who exercise power and ordinary people? Now, if I'm right, AI leaves no room for judgment or deliberative reasoning, interpersonal engagement, or decision-making responsibility. And there are 5, I think, unfortunate consequences of this. First, there's disengagement from the world. AI mimics, but doesn't inhabit our world, the world in which we as human beings live, interact, shape our plans and projects and actions, and build our relationships. There's no room for judgment-enhancing, world-engaged elements like common sense, empathy, compassion. Kant thought that in order to make the move from a concept which he thought of as a rule and its application, we needed Mutterwitz. What's that? Sort of the common sense you learn at your mother's knee, a Mutterwitz. AI doesn't provide that. So it can't understand the meaning of certain actions of individuals and of the state or officials, or their impact on our lives. For example, the experience of subordination, the limit on one's freedom, the challenge to one's dignity, doesn't have the capacity to grasp that, to understand that, to appreciate that. So dimensions through which those who are affected by this mode of social ordering can't understand or appreciate those interactions with them, those impact on them. Secondly, participation. AI dominated adjudication, for example, of civil disputes, or AI dominating the activity of criminal process, provides no opportunity for meaningful participation by those who are affected or by the public in those activities. Adjudication by persons of persons is replaced by administration by and of things. I hesitate to echo Engels, but it does sound a little bit like it. AI leaves no room, furthermore, so there's no room for recognizing or respecting dignity in these processes. Third, there's an impact on the law itself. Law not only is not only an instrument of governing power, it also affords resources, forums, for contesting power and for correcting law on which power often relies. Law provides means of self-correction. AI leaves no room for such contesting or self-correction. Of course, revision is possible, but revision puts all the actions of AI beyond ordinary people and puts them in the hands of experts. Fourth, accountability. Of course, opacity of AI algorithms and the like puts all of the actions of AI beyond persons. But worse, accountability of AI instruments is radically different from the accountability we talk about within the context of the rule of law. It's not a matter of assessing actions relative to values or norms. Rather, computational accountability is often talked about more accurately as explainability. An assurance of the reliability of the functioning of the device. So accounting is done rather than accountability. Counting and calculation rather than offering reasons and justification. The problem here is not that it's ineffective, but it's the wrong kind of accountability. Moreover, because it's necessarily always in the hands of experts, it can't function in a network of mutual accountability that helps us build a political community that is structured by and sunk deep into the ethos of fidelity. With respect, finally, to the mode of social ordering, while this regulation is, in a sense, impersonal, and so may be able to allow us to transcend typical human failings of partiality, although it hasn't quite done that yet. It transcends the personal dimension in problematic ways, I believe. It removes regulation from deliberative domain of those whose behavior is regulated rather than addressing it. It removes it also from our awareness and replaces government of persons with the administration of things. This, I think, is not emancipation. And it's even more problematic if it escapes our attention or our awareness. Finally, let me conclude with just a few brief thoughts about the impact of replacing law in the place of AI in the place of law as it affects our mode of association. So law makes possible, I have argued, or at least suggested here, a vital and invaluable form of social interaction and political recognition, of a vital form of community. It provides a vernacular, if you will, that members can use to navigate their social lives. And it provides a public means by which members can regard, respect, and deal with each other as co-members, and see themselves as a unity despite the differences, the deep differences that divide them. And it gives resources for them to negotiate and renegotiate the commitments of their common life together. All of that's lost if we replace law with AI as mode of social organization, social ordering. AI regulation carves up the polity into small bits, atomized bits, and doesn't help establish or sustain community among the bits. No resources are available for constructing or sustaining personal or communal lives over time. Its vocabulary is radically private or singular. So members can't really conceive or articulate or contest or revise their understandings of their common life together. Finally, without law, members are deprived of a key means of expressing and acting out fidelity to each other. In a way, it puts the value of membership beyond our capability. So let me conclude. It strikes me that this is all a very high price. A high price for efficient and effective regulation, even if we grant and could be assured that a noble end is being served and its distortions are mitigated and its benefits are distributed equally or equitably. Whatever aggregate benefits AI technology in the place of law might bring, high-valued public goods are lost. So let me just say, I've said nothing about the role of AI in the law. I've just addressed AI replacing the law. There's a whole lot that must be said about the role that we might still find for AI, though we have to find ways in which we feel we are in control, and not AI. And so with that, I'll conclude.
So I think, thank you so much. That's a really wonderful talk, and it raises both abstract questions about this ideal you've articulated about the rule of law and how it might not be satisfied if we replace law with automated systems. But also there's a further question, which is, well, but to what extent is that ideal actually being realized in the world as we know it? So if it's not actually being realized, then it looks rather different. We want to employ these systems. So I don't think we've settled on what the ordering is. Did you guys have any views?
I'm happy if I can follow on from that point, if that's helpful.
Brilliant. So can I ask that you go to the lectern, and we can begin with you, Natalie. Thank you.
Good evening, everyone. Professor Pastima, thank you so much for that presentation and for your book, which I read in preparation for this evening. Now, having read your book and listened to that talk, there is strong potential for my remarks here to be quite short, because I find it nearly impossible to disagree with anything that you've said. Yeah. Your description of the law's distinctive mode of reasoning reminds me why I was attracted to the study of law in the first place, and your account of the value of law as a mode of governance, as a framework that creates the space for compassion, for meaningful participation, for the contestation of the exercise of power, for accountability, for reparation and community, speaks to the reasons why I made the choice 8 years ago to work for a foundation that exists to extend access to the legal system to those who need it and are without it. Now, I want to preface what I'm about to say by noting that you were very careful to state that in this discussion, We should seek to compare like with like, not digital technology at its best with law at its saddest or worst, or vice versa. But truthfully, I'm not sure that conducting this discussion at the level of abstract equips us to address the challenge we are facing. Because the prospect of governance by AI, of the replacement or augmentation of large parts of the legal system with AI, is not some distant prospect. It is here, it is now. The project of AI in the place of law has powerful advocates, both within and outside the legal system, in England and Wales and globally. On the train here, I was reading an article by Dr. Seth Lazar, a visiting fellow at the Institute, who stated that we have to design systems and ethics for people as we are now, not as we should be. To put it a different way, context matters. So in terms of access to justice, where are we now? Both globally and closer to home, the picture is, to be frank, deeply concerning. As Professor Tassioulas points out in his paper on AI and the rule of law, OECD research estimates that less than half of the world's population live under the protection of the rule of law. In England and Wales, court backlogs are at record levels. Legal need is widespread. Surveys have shown that over the past 4 years, over half of all adults experienced a legal issue. Individuals with problems relating to immigration enforcement, welfare, benefits and discrimination, life-changing problems, were most likely to try and to fail to seek help. Recent research from the Resolution Foundation found that in 2022, 1/3 of workers at or around the wage floor, roughly 400,000 people, were underpaid the minimum wage in violation of labour market rates. The same research found that low-paid workers were the least likely to enforce their rights through the Employment Tribunal due to a combination of high fees, lack of support, delays and strain associated with the process. Even when they do and are successful, the awards are far too rarely enforced. The study reported that almost 50% of awards made in favour of employees are unpaid. Behind these statistics are children stuck in unsafe housing dying from mould exposure, parents struggling to feed their families, people who are made ill, ignored and exhausted by the very systems and processes that are meant to protect them. In this context, where the legal system that we have too often fails to deliver on its promise, and in a policy climate that has, at least recently, been dominated by a combination of techno-utopianism and demonstrable unwillingness to spend resources on the justice system, it is unsurprising that governance by AI, with its promise of cheap and speedy access to decisions, looks appealing to those in charge of the system. If the choice is framed as a decision by AI or the status quo, I fear that appeals to the value of law as a mode of governance, however valid, are the rhetorical equivalent of bringing a knife to a gunfight. So how then do we move forward, and how might we use the arguments that Professor Postema has advanced in doing so? I have 2 thoughts. So firstly, we need to end the culture of paternalism in our approach to instituting reforms to legal processes and democratise discussions around justice reform. Arguments for and against AI are often framed as a debate between people who conceive of the law as a tool for distributing outcomes versus those who believe that the law's virtue lies in fair process. In advancing these arguments, it's striking how often those on both sides of the debate make appeals to what people want to justify their claims, which is interesting when as a discipline we have made such comparatively little effort to ask them. Often our failure to ask the public what they think and want is a function of deeply ingrained legal exceptionalism. Simply put, we often assume that the justice system broadly and court processes in particular are too complicated for the public to have legitimate views about. Our collective failure to invest in programs to promote public understanding of the law have in fact made the system extremely vulnerable. In health and education, public concern about the expansion of AI has forced governments to row back from its expansion. To counter this, last year, we at the Foundation commissioned the first ever study combining polling and public deliberation to explore public attitudes to third-party use of data in court records. The research explored public attitudes to the reuse of court data for purposes including designing AI-based alternatives to litigation for those on low incomes. We found that a lower proportion of participants on low incomes who in theory stood to benefit from this development were comfortable with this than their higher income counterparts. In the deliberation exercise, participants made appeals to a number of the values that Professor Pistima has articulated, particularly around participation and the desire for a process capable of holding power to account, and deep concerns about the ability of AI to deliver this. Engaging the public, asking them what they want and need from the justice system is vital to build the case for governance by law. My second thought was prompted by Professor Pistima himself in his defence of the value of adjudication. Acknowledging that courtrooms and legal processes are often not paradigms of respect for the dignity of individuals who are subjected to them, he contends that this fact is not reason enough to supplant them with decisions made by AI. He argues that AI technologies eliminate opportunities for valuable participation by their nature and deep ambition, whereas the obstacles standing in the way of realising law's ambition are practical in nature. We can recognise and value this ambition to accord parties the dignity they are due and measure actual practice against this ambition and seek to bring practice closer to profession. And this is surely the key to resisting governance by AI. It is incumbent on all of us to ensure that the legal system lives up to its promise, investing in research to understand where issues occur, taking action to root out the problems that we know exist, bias, racial bias, gender bias, and ensuring that the public have the type of experience when they encounter the courts that makes them want to defend governance by the law. Perhaps, after all, the benefit of the threat of governance by AI is that it forces us to look inward, to confront our legal system as it is, and to redouble our efforts to ensure that governance by law fulfills its promise for everyone. Thank you very much.
Sarah, do you want to go?
Okay, thank you for inviting me, and thank you very much for everything that has been said so far. My 5 minutes is probably going to be very apparently an exercise in how to say you're not a legal philosopher without saying you're not a legal philosopher, and probably also how to say that you don't know what 5 minutes is without saying you don't know what 5 minutes is. Feel free to throw things at me if I overrun. I did have quite a strong idea of what I was going to say this evening before I turned up, and I've just jettisoned all that now, that given what I've heard and what I've been thinking about while I've been listening. So I'm a commercial lawyer, mostly, and by training, I suppose, is the best way of putting it. And now, as a law commissioner, I have lost the luxury that I had when I was a full-time academic of being able to grasp onto ideas and pursue them because I thought that they would give the ideal outcome. I say that because I think I might be disagreeing on some issues here, although I'm disagreeing in such a subset of law that we might actually come all the way around and say that what we are doing actually is agreeing. The reason I said the thing about being a law commissioner and being faced with a reality that I have to deal with. So AI is happening, as Natalie has said. We are already faced with it. Parties are already interacting on the basis of algorithms on a huge scale. And so one of the questions that I've been faced with is, how should the law respond to that? Now, I think that the subset that I've referred to is commercial law, commercial parties, and maybe a little bit broader, contract law. Of course, the essential element of contract law is agreement, it's consent. It is a mutual it's a meeting of minds, it's a mutual identification of the way in which you want your dispute to be regulated and to be taken forward. And so my question, as we were hearing about party integrity and party autonomy and being governed in quite a passive way. Of course, all those things don't apply in quite the same way when what we're talking about is a commercial contract situation. if parties, so we've already seen algorithmic dispute resolution being signed up to on quite a large scale. So of course that's parties saying, if X happens, then we want Y to happen as a result. If you've both done it, if you've both been informed, if neither of you is under duress of any kind, then why should the law not say, okay, well, when that happens, we will step back, or it will step back, and the parties can use the algorithm that they have fastened on to resolve their dispute. So I guess that's a question. And what we're really talking about here, it's the other end of the scale, really. I think there are ways in which artificial intelligence, I know that's quite a generic term, and I'll give a couple of examples, can actually democratize law in a way that is not possible without it. So what it does allow parties to do in certain situations is to set up their own dispute resolution model. And of course, as long as they're both happy with it, and of course what we're not talking about here is any harm inflicted on anyone that the state would be interested in. That is a separate question. So I am constraining my remarks to the commercial arena, but it's a very important arena, not least because the more parties that set up their own dispute resolution systems and then adhere and are quite happy with the outcomes, the more resources and the more legal resources there are for those who aren't in that position and who have to resort, and we would want them to resort, given what we've heard about discretion and equity and mercy. There are many questions for which those are the obvious tools to use in relation to. Now, one of the things that really interested me when I first started reading about AI systems was in the context of chess. And of course, artificial intelligence is very important to chess players, increasingly so. And in fact, Magnus Carlsen, who, for those of you who don't know, is one of the best chess players in the world, we'll leave the recent controversy aside, not that that was directly him. But anyway, Magnus Carlsen, fantastic chess player. And he was, at least by his own account, one of the first players who excelled in the artificial intelligence era. So the era in which chess players practice against artificial intelligence. And of course, artificial intelligence has this amazing, sort of, to me, incomprehensible store of data. So how did he do it? The way that he did it was he started making deliberately non-optimal moves, because that, of course, confused the AI, and that's how he managed to beat it. So what does that tell us? That tells us if you're a party who wants to, I mean, I think all of this also makes us question, as commercial lawyers, we are always told, and we always say, in fact, what we're looking for is certainty. What commercial parties want is certainty. Now, AI gives you certainty. Of course, it changes over time because it's only as good as the data you feed it, but it does give you, I think, more certainty than human discretion. It may learn guile over time, but it certainly doesn't have it in any instant way. So what does the Magnus Carlsen experience tell us? Well, if parties do want that predictability without the possibility of mercy or capriciousness, or the sort of equitable response of a human, commercial parties don't necessarily want that. For obvious reasons, it's not usually their livelihood or their welfare at stake. It is simply their financial resources. And actually what they do want is certainty. What they do want to be able to do is say, well, if I behave in this way, then the outcomes will be within a much smaller subset than they would be if we weren't using an artificial intelligence. Because, of course, commercial parties just want to be able to price their behaviour and to factor that in. And so if they can do that, then my question is, why should they not be allowed to? And then leave that pie, that sort of jurisdictional and court resource pie, alone for those who really do need it. How long have I got left? 1 minute. Okay. So I've got one final thought then, and it's again in support of AI. And as I said, it might not really be a disagreement, I don't think, because I certainly do not think that robots should be taking over the world and that everything should be left to AI. But I do think it has a lot to bring to the law party. Now, the other example, the concrete example that I wanted to use was one of the projects that we have at the Law Commission at the moment is how to reform the law to accommodate decentralised autonomous organisations, or DAOs. Now, these are effectively, again, for anyone who doesn't know, apologies if you're completely familiar with it, but a decentralised autonomous organisation is essentially a company that's run by virtue of smart contracts. So it's a coded company. And of course, what you can do with a company like that, because it is all based, all the decisions, all the governance decisions are made on the basis of algorithmically determinable solutions, if X, then Y, and then the code works through and everything happens. What, of course, you can do is you can ensure in the code that governance happens as it should, and that the law is adhered to, and that the company's acts are, they are doing what they are supposed to do, because there is no room for human error, negligence, criminality. Now, of course, there might be at the coding level, but it certainly reduces that, and code can be checked before it is run. I'm pretty sure that was my last minute. So I will end there. Thank you.
Thank you so much to John and to the whole Institute for bringing us together. Thank you, Jerry. It's a pleasure to be with you. And I thought I should bring you a horror story. And I've got it here. This morning, and I'm right at the cutting edge, Jerry. This morning at my kitchen table, I gave my son, who is innocent of any legal training, the question, should the court in judicial review defer to an administrative authority's interpretation of the law? Should the court defer to an administrative authority's interpretation of its own policies? He has ChatGTP, and in about 4 minutes, he came up with an answer that I graded at 58, which is a high 2.2, a second-class result. And he thinks that I was biased against it because I knew that it was coming from this dodgy source. And the striking thing about it is that although he's not a lawyer, when he got the output, he realized that there weren't any sources in it. So he put in another prompt saying, please can you cite appropriate cases that justify the points made in this essay? Here's what it said. I apologize for the oversight. I have now included relevant case law to support the arguments made in the essay. Now, it was still banal and interesting that the cases it cited, important cases, were not well used. It didn't show the ability to do something with a particular judicial decision to make an argument. So you're never going to get a 2-1 or a first using ChatGTP unless they develop it, and they'll do that by the week after next. So there's my horror story. The implications are stark for the integrity of our students and for the future of legal education, which I'll comment on briefly at the end. But I did want to say something in answer to Jerry's question. What if value would be lost if we replaced the role of legal reasoning and social ordering by the capacity of machine learning to come up with outputs that simulate argumentation? Jerry says simulation replaces argumentation. AI technologies replace accountability with accounting. And I broadly agree yet I think I agree with Sarah Green as well. I agree with Jerry if we think of a general policy of replacing rule by law of a political community like this with ordering of society by big data and by artificial intelligence solutions to problems of big data. Here's what we would lose. We would lose intentionality in social ordering, which means we would lose personal responsibility for decisions as to matters of private concern, we would lose public responsibility, responsibility of our community for decision in matters of concern to the community. And on that broad agenda, if that broad agenda were pursued, that's a catastrophic loss. We would lose, here's another slogan, like simulation replaces argumentation. We would replace process with processing. Legal process comes up in what Jerry said today in his book, and it's so fundamentally important. Legal process is a systematic array of techniques enabling intentional decisions by human beings to have effect in the ordering of society, and we would lose that. The general sort of move that I'm imagining, well, on an intestacy, the testator's goods would be distributed by big data analysis of their preferences. This is something that's actually been recommended in law journals. Speed bumps. We would wake up tomorrow and the speed bumps would be there. ChatGPT or another algorithm could determine where they are to be. And in those cases, private and public, what would we lose? The intelligibility of accountability for the distribution of a person's property. The intelligibility of accountability for the public decision about just how bad it's going to be to get home on my street, or just how bad it's going to be when everybody else is trying to get home down my street. And for those decisions, we ought to have responsibility. I agree with Sarah, because if you think for a minute about the speed bump situation, I think the decision makers, I think they ought to be responsible, and that the decision to put a speed bump ought to be made by a public agency through intentional decision making for which it's conceivable that they could be accountable and for which they are responsible. But it might be so good if those decision makers had ChatGPT or another facility to do the modeling. Accounting, even Jerry says that it's good to have, that AI would be useful for accounting. So wherever accounting would be useful in public policy making, bring it on. Modeling, potential massive democratization of information and assessment of policy. These are great goods, and we shouldn't lose track of them just because it would be a terrible loss to give over the governance of a political community to ChatGPT. So I just want to close by asking the implications of ChatGPT for what us academics do. Do you know what? I'm not going to use it in my research because I find the ingratiating tone just weirds me out when I'm talking to it. Listen to me. When I'm reading the output from an algorithm, and here I am trying to think, who designed this, and how did they program it to apologize, or has it done some machine learning magic that makes it produce an output that is the same as if it were apologizing? That freaks me out. But there could well be other similar techniques for research that would be brilliant and brilliantly useful. And that's a matter for the future. What about teaching? What about our students? They could get from ChatGPT a lot of what they get to us, and the week after next it'll be better. I'm still ahead of it, I think. I can outbluster ChatGPT even now. And it's not just outblustering. I have an intellectual gift that all of you have that it demonstrably lacks of focusing on the particular illustration or the particular turning point in the law or the particular ground for decision. So I don't know how long we'll be ahead of them in that respect. But here's why I don't think we should replace our teaching by giving students ChatGPT. There's the potential that I could understand him or her. And they're not there yet. in AI. Thanks.
Thank you. I'm tempted to say that a truly ingratiating ChatGPT would have gotten a first, because it would have cited to Professor Endicott. Okay, so I think what we're going to do is maybe allow Jerry a chance not to sort of feel the need to respond to everything that's come up, but to pick a few highlights and respond to that, and then we will throw it open to general discussion from people present and online. Jerry.
So I am here. I'm pleased to have these comments, and that brings completely to mind the need I have to interact with people closer to the ground than I am at Google Earth. I have a wife who is a serious practiced lawyer for a long time, and she read a good bit of this book, and it's so much better because there's even at one point where I was citing a case and describing it, and she said, "That's wrong." "How do you know?" I said. She said, "Because I was the lawyer of record in that case, and it didn't go like that at all." So bringing things together is really important, and I value these kind of comments a lot. What I hear, for the most part, are suggestions about how there are things that algorithms and AI can do, and maybe do well and do better. And I'm perfectly willing to accept that as a possibility. I think we would have to argue particular kinds of cases, like, for example, the ones you've mentioned, to see whether they actually perform on their promise. I should say, Timothy, that I gave up teaching. I'm now emeritus, now for 4 years, in part because I got the feeling that I didn't know where my students were anymore. And that was 4 years ago, right? Who knows? I mean, they didn't have chat bots available to them then. But there are two things that I wanted to mention here that I think are of a serious concern. And it came up in part with Natalie's comments. I really like the idea of getting over this paternalism business. And Sarah's. And that's the thought, maybe the hope, that at least for important parts of the law, especially where computing or getting reports and doing that kind of research can be really valuable. I agree that there are such. One of the things that might be made more available to us is just access to justice. We are very bad at that. I can talk about my own legal system and not yours, but we are very bad at that. If we could find some way of having the law actually more accessible to people who are not already wealthy and educated, so much the better. I really believe that's so, but here's my worry. I remember, now is it maybe 20 years ago, when we all thought that the internet was going to be the great democratizing force. And what's happened? Just the opposite. And my worry is, maybe we learn. We're not in the mode anymore at the institutes that develop these things, in the mode of rush ahead and break things. We're much more careful, perhaps, but we need to be more careful. And the problem is that the technology is a lot further along than our understanding of how these things work. So it gets away from us. And I worry, not in particular cases, but because of our terrible experience with the internet's failing on its promise to be democratizing, that this will fail too. A good friend of mine, Paul Gowder, now at Northwestern, has already argued that the promise of the sort of egalitarian promise of AI is likely to work just against it, because what it'll do is it made these really efficient processes even more available to wealth and to those who can get the wealth, the algorithm manipulators to do their work. And if that's so, democratization will fail. That worries me. Maybe I should just stop there because we have more questions. I really wanted to talk about private dispute resolution. Let me just say one more thing about private dispute resolution. But this is not really a new thing. There have been arrangements for commercial relationships that try to get around the law because law tends to be far too costly, and so in mediation or arbitration, mandatory arbitration, like we've had those devices. They're not AI driven, but they're those devices for a long time. And the one concern that sometimes comes up is that what it does is that not only it might serve the interests of the two parties, but there's a public good involved in there being a legal process available to those two parties. And that public good of managing the law and manipulating it and correcting it and will be lost. And I'm afraid that might be the case also there, but we need to talk about the details. Thank you.
I think just to pick up on that a little bit, this issue about democracy, I mean, there's already, as part of the breakup of our democratic ethos, a way in which the rich have departed from the rest of us and live in a different world. And one of the ways they've done that is they no longer care about our broken legal system because they resort to arbitration.
Yeah.
And some of our great judges and legal academics get paid huge sums of money in order to operate this parallel system. So, as it were, that's already a kind of attrition that's happened to our democratic culture. And potentiality, and I take Sarah's point that it is attractive to think you could divert some resources from commercial disputes and then have more resources, but it also risks further entrenching the idea. Basically, the rich are no longer our fellow citizens, but they're people operating at a different level, kind of shadowy level, doing their own thing.
A non-legal black market.
Yeah.
There is just one wrinkle to that as well, though. When I was referring to commercial parties, and in the most part, I completely agree. But there are some examples, I think, where one side is commercial, but the cheap dispute resolution does actually favour the small person, as it were. So, with parametric insurance contracts, so the obvious one that was used was if your flight is cancelled, you as whoever you are, you might not have any resources at all, but all you have to do is get the algorithm to confirm that your flight was in fact cancelled, and then the money that you are then due is automatically assigned to you. So in the main, absolutely, but it isn't only the big commercial parties that can...
I think this is one of the interesting things about Jerry's paper, that in a way, Jerry, you made things a bit easier for yourself by, in a sense, talking about wholesale replacement of law.
Right.
But someone might say, well, look, there's an element that's just pure drudge work. There's an element of minor forms of issues where your procedural values, important though they are, could be legitimately trumped by other sorts of concerns. Yeah. So I think, in a way, that's the kind of practical end of this problem, when that's appropriate. Right.
So one thing that I take that point completely. The rule of law is one important value amongst others, and it has limitations. And the limitations are sometimes on the value itself and sometimes on what law can do. And if we can find other ways for law doing that kind of thing, then it may not be inconsistent with the rule of law.
One observation, John, if I may, before we open up to... So I think there's another type of threat here, so which is partly driven by the economics of how these things work. These tools are primarily developed by private companies, and the real attraction is in those kind of low value, high volume areas of the justice system. Which is where the majority of people interact with our legal system. And if we are to say that actually, for reasons of economics, we're going to lift all of those people, all of that volume of disputes out of the system, it creates this, where are people's interactions with the law going to come from? Part of what I was trying to get across in my commentary is that, you know, one of the reasons why the law is so vulnerable to take over by these particular technologies is because there just isn't the good experience that people have with the justice system to advocate for it. And I worry, exactly as John's expressed in shorter and more eloquent terms, that we end up creating kind of two-tier justice system and undermine our democratic values and the rule of law further, because people don't realise the practical value of it unless they're interacting with it.
Now, I really do want to go over the questions from the audience. So who wants to kick us off? Yes, there's a question here at the front.
Jerry said that...
Well, can you just wait for them? Thank you.
Professor Postema said that architecture is the rule of social behavior, or the guidance of social behavior in non-deliberative ways, or much better than that. But we're never free from architecture.
No.
And I think when we're discussing these questions, artificial intelligence, the way it affects our lives, the way it affects our culture and our legal system, depends on the architectures in which it's implemented. So I've noticed this discussion is largely about, do we use artificial intelligence or not? And I think it should instead be about, how do we use artificial intelligence? How do we architecture our use of artificial intelligence so that it supports what we value and the objectives we want to achieve? I don't think that an approach of let's not use artificial intelligence is likely to succeed, but I think one in which we carefully architecture it could very well so.
Thank you. Can we just collect a few more questions? I mean, assuming they exist. Right at the back.
Right, my name is Conrad. I'm one of the DPhil students here. So my question is about something you said, Professor Postema, that one of the problems with using AI as a legal decision maker is that AI doesn't have the tools for its own self-correction. But I wonder if the case might be even worse, because if you involve AI as a decision maker, and it increasingly adds into our body of precedents, and if every precedent changes the rule by applying it in a new context, then over time, are we not inherently and inescapably assigning control to AI over actually what the law is and will become?
There's one more spot if anyone wants to take it. Linda.
Thank you very much. This is a quick one. I was curious to hear a little bit more about democracy. So you've spoken about the rule of law a lot, but it seemed like democratic values were sort of like the elephant in the room. I was wondering if you could make that a little more explicit, what the relationship is there.
Okay, let me reply in that order. Yes, indeed. You know, I mentioned this arrangement we have in my hometown where things are... That's a pretty good way of doing it. That's architecture in an effective way, keeps people from going too fast through residential streets. I like the idea. And the question is not architecture or norms, it's where we deploy them, how we deploy them, how responsibly we are in deploying them. And when it's architecture, are there points where we must introduce some kind of accountability? And what form would that take? Absolutely. And so John was quite right to say, I've made the case easy for myself by putting it in terms of... I do it all the time. So. Yes, that's right. Yes. And that's right, because there was just one kind of problem I wanted to address here that opens the door for just these kinds of questions. And each of my commentators have suggested various parts where one could really put much more attention into it. And I confess that it's they who will need to do this, because I don't know enough about it to be able to say anything intelligent. I can just say some things about what values are at stake, what concerns are at stake, and then we have to do the really hard work of design. Design is what we need to do, but we have to be motivated by and see the background of the values. But tools of self-correction, I'm puzzled about this self-correction idea, because in some sense, you know, at least as I understand the way the algorithms now work, so that gets Timothy's paper on a legal issue, is that it's working with all of this stuff, and it does some kind of statistical analysis on it, and then it issues an outcome. Now, suppose that gets plugged into the data. That's a new one, and then you get plugged that into the data. And it might be self-correction, it might be self-corruption, right? And we need to have some kinds of controls on that kind of thing. When I talked about correction or revision, I really meant, well, it looks like these outputs are not doing what they're supposed to be doing. They're not meeting the design, and we got to go back and change the design. I mean, the thermostat is not actually measuring the temperature in the room and shutting down the furnace when it has to. But this is a little bit different, right? It's sort of internal to it. So the potential for self-corruption, it seems to me, is pretty great. On democracy, I just did a talk in a couple of different places on the rule of law and its relationship to democracy. And it's a long story, but my particular view is this, very quickly. Rule of law is one thing, democracy, one kind of important value, democracy is another. They are distinct values. It is conceivable that we could have a community governed by a relatively robust, conceivable, robust rule of law, which doesn't meet best standards of democracy. However, they are so intertwined, so interdependent, that it's really, that conceivability is not a practical possibility. They are, as I want to put it at one point, the democracy can work only if there's rule of law in place to protect all those features of democracy. Think of election structures and the like, that have to be maintained in order for democracy to thrive. At the same time, a democracy that the rule of law that doesn't issue into something like democracy is like a promise that's unfulfilled. There's an ambition behind both of them, and it's an unfulfilled promise that we're still working on.
I'm going to turn to the commentators for any of their concluding thoughts, but I just wanted to ask you one question to pick up this idea that the rule of law is one value amongst others. So in your account of the rule of law, you said it's a corrective to arbitrary exercises of power. So I'm wondering, are there any bad exercises of power that are not captured by that? Or do all bad exercises of power count as arbitrary?
Well, it's as arbitrary. There could be bad exercises of power that are not arbitrary in the sense, I have sort of two ways of, there are the number of ways of understanding arbitrary. The way I have it in mind is that an exercise of power is arbitrary if it is not guided by intelligible norms and there is no mechanism for holding the power wielder accountable to them. Other people will define, I think even Timothy will define arbitrariness in terms of it's not tracking reasons that apply to one, or Philip Pettit would talk about is not tracking one's interests or the interests of those to whom the law is addressed, those or the power is addressed. There are various ways of making it out. That's the way I understand it. There can, however, then be non-arbitrary exercises of power that are bad, that are unjust, that violate rights.
Right, so that's what I was trying to get at. So it sounds like, and I actually agree with this, but I thought you weren't going to embrace this, that you could have compliance with the rule of law with quite a lot of injustice and quite a lot of rights violations happening.
Absolutely, and so the lecture I was just telling you about actually was rule of law, human rights, and democracy. And the argument was, they're distinct. It's possible for there to be rule of law and violations of human rights, and violations of and undermining of democracy and back and forth. The problem is that these quite different but very important concerns of our political morality are really intertwined. So, for example, some of the most important human rights also are the kind of things that the rule of law also supports on different grounds, right? To put it a little bit of a different kind of case, there are human rights which, if they were systematically violated, it would be hard to be consistently committed to the underlying principles of the rule of law and think that that's an appropriate way of dealing with human beings. There's a kind of practical contradiction in that. Not a theoretical one, not a logical one, but a practical contribution. How could you be so committed to the principles of the rule of law and yet see that the way in which you're proposing to treat people would be appropriate? That's the kind of relationship.
Makes a lot of sense. Now, I'm going to steal a few more minutes to give commentators a chance to say. So, Timothy, do you want to start us off? Or something from ChatGPT, whichever.
Yeah. One thing that I didn't get to in my talk that I think is something to learn from the issues that we've been considering. It concerns the purpose of social ordering in general. I was thinking about process, having read what Jerry said, the importance of process. I was remembering what people call the legal process school, that several people in this audience will be familiar with. Henry Hart and Albert Sachs taught a terrific course at Harvard in the 1950s, tremendously influential in the history of ideas in America, and in particular in legal academics and legal thinking in general. And they started from the principle that the purpose of governance should be to maximize valid preferences. And then they did some really good lawyering on how to get there through processes that allocate power in intelligent ways, and they were really sensitive about this, that get us as close as we can as a community with our different opinions to the maximization of valid preferences. And I think some of what Natalie was doing in her talk today would fit right into the legal process school, thinking intelligently about how the interests at stake can be represented through intentional action of participants in a process in the best legal sense. And process generally, they were lawyers without a sort of narrow vision. They were thinking not just about adjudication, but about administration and legislation and constitution making and negotiation and private ordering, as they called it. Now, imagine in the 50s they had had AI as we have it today, or will have it the week after next. Would they have said, oh, whew, valid preferences can be maximized without all that stuff. We don't need process. We've got processing. Well, I hope and I trust, because I think they had good instincts, that they would not have said that. But then they would have had to say, wait a minute, the maximization of valid preferences. By the way, the word valid, I love the word valid in that manifesto, because they didn't say what was valid, so they didn't have a theory of what's right and wrong. But I think they would have had to face up to the fact, if they thought about what we've been talking about, that the maximization of preferences is not actually the point of a legal system. Mm-hmm. The point of a legal system is to order a community in a rule-governed way that enables the right actors to intentionally make decisions that will order their private relations and the organization of their community in the interests of justice and the good of the community. So I think this is actually quite significant for the purpose of government. It's not to maximize preferences. Yeah. Or we would be better off with the machine on the assumption that the machine is not just really clever itself at learning, but also not biased.
Unless we had some deeply ingrained preference to make our own decisions, I guess. But that isn't the reason, though, that you would say we should value that. Sarah?
One wonders whether Bentham would have been happy to welcome ChatGPT.
Well, you would know, if anyone.
And
I suspect he would.
Sarah.
Yeah, on efficiency grounds, if nothing else. Yeah, I think the thing I want to round off with is something else I didn't get to touch on in my first 5 minutes. Is really to make, or at least I mean I didn't do this in any sort of crystallized way, but make the point that my objection to the objection about AI only goes so far. And really what I was saying about algorithmic dispute resolution is of course all well and good if what you're talking about, or what we're talking about is I guess a sort of horizontal application of law. So, you know, we know what the variables are going to be and we know what the rights are in relation to those variables, and so do the parties, which is why they sign up, of course, because they in a sense know what they're going to get. But of course, the real beauty, particularly of the common law, is its ability to develop in a vertical way and not just a horizontal way. And then there's a strange sort of existential question for me as a law reformer here that AI would be really bad at law reform. Obviously, it couldn't tell us what to do about itself, because what it does do, at least in its current form, what it does do very well is, I was going to say reason then, I'm not going to use that verb, it computes by analogy. What it cannot do, of course, is cope with any paradigm changes, and that is what the common law occasionally needs to do. And so I agree in an enormous way with what Professor Pastima was saying on that point, that certainly there are, I mean, really what I'm saying, I suppose, is horses for courses, and I think that there are some ways in which artificial intelligence can really help us with legal resolution, but it is by no means the answer to everything, and most of what I deal with on a day-to-day basis would not be able, and what most common lawyers deal with on a day-to-day basis would not be resolved or resolvable by an artificial intelligence. The interesting stuff, really, you know, as John said, it's really the grunt work of lawyering can, I think, be done by artificial intelligence. So that's those those horizontal applications and drafting of, you know, very standard contracts and things that at the moment parties still pay quite a lot of money for when there's no need to.
And Natalie.
Thank you so much. So, I mean, I just want to say this has been such a really interesting exercise, and I've been struck by how difficult I've found it to remove myself from the contextual issues, because I think, you know, my concern and my response was driven by the sort of value proposition of replacing law and decision making with AI, but also the knowledge that the areas of the justice system where these technologies are most likely to be deployed, and the underinvestment in the infrastructure that is needed to make those technologies fair in that context has driven a lot of the concern. But nevertheless, I really commend this book, and I really enjoyed having the opportunity to, you know, see set out so clearly an articulation of what we should be seeking to defend when we're talking about the value of the justice system. So all of which is to say I've really enjoyed the discussion, and thank you so much, Professor Pastima, for the book.
Thank you.
I'm going to seize that positive note as a note to end on. So thank you very much to Jerry for coming here and giving us this wonderful talk, and also for this spectacular panel, actually, and the really great discussion that we've had in consequence. And thank you to everyone for joining us. Thank you.